Good morning, everybody. Thank you for joining us on the day that we're observing Veterans Day to talk about Washington's new paid sick leave law. Meg and myself, Catharine Morisset, are here in the Seattle office. We are happy to have you all on the phone with us. The law has a lot of ins and outs and a lot of complexities. In fact, it's so complex, we still don't even have all of the regulations yet. We're waiting on the enforcement regulations. Those are still in rulemaking process. So we're going to talk just a little bit about those at the end, but we'll start off with what the basics are that employers need to do and not do with this brand new law. We hope to have time to take questions at the end. If you want to type questions throughout and I have a chance or Meg has a chance to look at them, we will do our best. But our plan is to have questions at the end, and we also will send a copy of the slides to everybody who attended today as well. So there's a few slides where there's just a lot of dense information that we'll touch on briefly, knowing that you'll be able to refer to them later. So we're going to start out with what's happening, talk about who's covered and who isn't. We will talk about what we do with Washington and all of the other city laws and how they interact. We will share employer responsibilities. We do know at least one of the enforcement pieces is going to be an anti-retaliation provision. And I put on the end, no, really, what about the different city laws? Because I know many of you on the phone have operations in multiple jurisdictions, and trying to put this all together is really going to be the challenge, not only from legal compliance, but for what it is you want to do as for employee morale.
So what is happening? In November of 2016, the Washington voters approved a ballot measure that requires employers to provide paid sick leave to most of their employees beginning on January 1st of 2018. But why? Well, they're trying to promote public health, family stability, and economic security balanced with the demands of the workplace. This new law includes provisions addressing the accrual and carryover of paid sick leave, defines what paid sick leave can be used for and when, and prohibits employers from retaliating against employees for exercising their rights under this new law. So who's covered? All of these lovely people are covered under this law. It pretty much applies to all employees and employers that are covered under the Washington Minimum Wage Act. So to give some more detail in that, an employer will include any individual, partnership, association, corporation, business trust, or any person or group of persons acting directly or indirectly in the interest of an employer in relation to an employee.
And there's no size limits on the amount of employees, right, Meg?
Correct. So it pretty much applies to all employers. Now, employees, it applies to most employees, and here's some of the carve-outs. I'm not going to go through all of these because they're listed for you, but one of the ones that we really want to pay attention to is the white-collar exempt employees. So what does that mean exactly? So that means a bona fide executive, administrative, professional, or outside salesperson. And you need to remember that in Washington, Washington has its own specific tests for what qualifies for these exemptions, and those tests aren't exactly identical to the FLSA tests under the federal law.
And these are some of the most common issues we see where people are classified incorrectly. So here's yet another reason to do your exemption audit, not just for potential wage claims, but also for paid sick leave reasons as well. And of course, this leaves open the question for me, am I going to give everybody paid sick leave, but I'm not going to give my properly categorized managers paid sick leave? Sounds like that might be a morale issue that employers will need to consider. The other person that is exempt from the paid sick leave law is a true independent contractor. Again, we emphasize bona fide independent contractor because this is one of the most common misclassification issues we see when it comes to wage hour claims. And by the way, this is now not your get out of jail free card that you're going to turn all your employees into independent contractors so you won't have to provide paid sick leave, that likely will not work and lead to a number of claims against you. So in the introduction, I still wanted to touch about what are we going to do about the various municipalities. Well, the city of Spokane specifically has a sunset clause, so that law is going away. Tacoma has done some work to make itself match Washington law, but it still doesn't match exactly. Seattle's done nothing, and same with SeaTac. There is no provision in Washington paid leave law that says it trumps what the other cities do. So you have to follow them all. And if there's a more generous provision under a city law, you still have to follow that, even if the Washington statewide law says something else. That's tricky enough. We're going to talk about it later, but I wanted to introduce the concept here. All right. The main compliance point is all employees who are covered must accrue at least 1 hour of paid sick leave for every 40 hours worked. The accrual must begin on the day the employee starts work, or if you've got existing employees, this is going to kick in on January 1st, 2018. Again, if Seattle has more generous policy because of the size of your business, then you're going to have to follow the higher accrual rate. A lot of folks that we worked through paid sick leave issues with, either nationally or here in the state or with Seattle, like to talk about using a front-loading method instead of accrual. That is lawful under the new law. However, you've got some buts. One of them is that you have to be doing amount of a front load that would have been equivalent to what the employee would have otherwise accrued. And remember, overtime hours count. So I've had clients get into a little bit of trouble because they estimate somebody working just full time, and in fact, they put in some overtime and the accrual rate's off. So you need to consider that when you're considering the amount of front loading. If you're going to front load, you must have a written policy. This isn't just something you can do by practice. We would encourage you to have a written policy on paid sick leave anyway, because it's going to be probably your Exhibit A in any lawsuit or governmental investigation regarding compliance. And I happen to think that it's good for us to communicate with our employees about what their benefits are. Right, Meg?
Absolutely.
Okay, here's some other cautions for front loading. Look, you can do more front loading than the minimum accrual. Of course, it can be more generous. If you're more generous, though, you can't ask your employees to pay it back to you at the end of the year. That's not going to work. If you front load and you don't give the employee enough that's the equivalent of what they otherwise accrued, the law's only giving you 30 days to fix it once you know about it. So you really should be on top of it if you're trying to just front load, really write it what the accrual would have been. And you can't deduct front-loaded paid sick leave from a final paycheck unless you've got an agreement in place to do so. Let me explain what that means. In Washington, really the default rule is if you are not going to pay out unused PTO at termination, you need to say that in a written policy. Otherwise, you're going to have a hard time showing that you don't owe it to your employees. But our state does allow folks to not pay it out provided you have a written policy. The last concept that I think employers always understand, but employees sometimes seem to have a difficult time with it. I chuckle because it's funny to me to think that you could accrue paid time off for when you're not actually working, but in fact that is the rule and something I would encourage you to have in your policy. When can employees use it? All right, so employees start accruing day one. You're going to be reporting it on their paychecks as of day one of employment, but you can have a delayed time to use of 90 days of employment. For those of you with operations in Seattle, this is earlier than Seattle's law requires. So that means even for employees in the city of Seattle, they're going to have their paid leave available now as of their 90th day of employment. When can employees use paid sick leave? Well, this is similar to reasons that you may have thought. So we've got the 90th calendar days of employment. The trick for monitoring it is a little bit difficult because we need to use our paid sick leave in increments that are consistent with whatever your payroll system provides. So if your payroll system does lawful rounding according to the FLSA or Washington state law, like a 6-minute rounding, you can do that for PTO. That's fine. If you round, if you do 15-minute increments, that's going to work as well. The problem for employers is going to be where you have a timekeeping system that tracks to the minute. The way the law is written, you should also be tracking PTO to the minute. Otherwise, you need to obtain a variance from Washington state, and that's a long process that you probably need a lawyer to help you with. But for now, the rule is it has to match how you track time in your time clock.
So let's talk about using paid sick leave. So employees can use paid sick leave to care for themselves or their family members when the employee's workplace or their child's school or place of care has been closed by a public official or for health-related reasons, and for absences that qualify under Washington State's Domestic Violence Leave Act. And of course, you can give your let your employees use the paid sick leave for additional purposes if you would like. It's important to note that there is a difference in the definition of family member under Washington's paid sick leave law versus Seattle's paid sick leave, sick and safe leave law. So under Washington's law, they have the child, which includes a biological, adopted, or foster child, stepchild, or child to whom the employee stands in loco parentis, is the legal guardian, or is a de facto parent. And then they do the same for parent, spouse, registered domestic partner, and grandparent. Keep in mind, though, in Washington, they also include grandchild and sibling, which is not included in the Seattle paid sick and safe leave law. Seattle includes parent-in-laws, which is not included in Washington State's paid sick leave law. So remember, you need to be aware of all of these when you are writing a policy if you're in Seattle. So when an employee needs to take paid sick leave, there's different notification requirements when the leave is foreseeable and unforeseeable. If the leave is foreseeable, employers can require the employee to follow any policy in place for notifying the employer that they're going to be out for the day, as long as the policy does not interfere with the employee's lawful right to take the leave. If the leave is unforeseeable, the employer can still require notice from the employee, and that notice can be as soon as possible before the required start of the shift, unless it's not practicable to do so. In the event that it is impracticable for the employee to provide notice to the employer can have somebody on their behalf call into the employer and let them know that they won't be in that day. Employers have to have a policy that states this, and they have to have that policy readily available for their employees, and they have to tell their employees what that policy is. However, if the employer does not require an employee to give reasonable notice for using paid sick leave, then no policy is required.
So it sounds like that's either a handbook amendment or it's time to do a standalone written policy that you circulate to your staff and probably put up onto your bulletin board.
And certainly make your staff aware of.
Okay, here's the next questions that we tend to get, which is, can I ask for verification from medical providers? And the answer is you can, but the reasons are a little bit more narrow than they are under Seattle law for any of you who are familiar with that. So the concept under Washington's new law is if you've used your paid sick leave or your PTO, if it's a combined policy, for an absence exceeding 3 days during which you were required to work, the employer is allowed to provide, to demand rather, a verification within a reasonable time. So what does an absence exceeding 3 days mean? Well, the regulations have given us an example that's a little confusing that frankly Meg and I had to read through several times to be sure we understood it. And maybe this is something that we'll see straightened out in the FAQs, or that the state can answer when they start doing their webinars on this. But the definition is an absence exceeding 3 consecutive days an employee is required to work. So Meg and I read that as you look at what the employee's schedule is, and then you count the 3 days. The example they gave in the regulations is an employee who's scheduled to work on a Monday, Wednesday, or Friday, and they call out sick either for all 3 of those days or part of each of those days, so that they were sick 3 days on which they were scheduled to work. If that employee calls out sick on the next day that they were scheduled to work, then we have an absence exceeding 3 days. A little bit confusing, but we think it's a matter of counting how many days they've missed based on what their scheduled time is. The new law doesn't answer one question that's very important to employers when you're addressing leave abuse situations, unfortunately. The law is silent on whether an employer can require verifications if there's a suspected use or abuse. In Seattle, for example, you have that ability. That's the person who seems to always get sick on Mondays after the weekend, and then you ask for verification from a medical provider. We have nothing like this in the regulations or Washington state law. So for now, the rule is going to be you have to count those 3 consecutive days. The other concept that is new under Washington law is that the rate of pay for the paid sick leave is defined as the employee's normal hourly compensation. And just know that only means the employee's hourly rate if that's how they're normally paid. So somebody who works minimum wage, then it's going to be minimum wage. But what you're really supposed to do is examine to see what they would have otherwise been paid had they come in that time that they used leave for. And this is tricky. All right, we've got some things to help us figure out what's normal. We don't have to pay the employees for tips, gratuities, service charges, holiday pay, or other premium rates, unless you've got an agreement that says you're going to do that. All right, so that's good. There's some things we can exclude. However, if you have employees who are owed shift differential based on a collective bargaining agreement or other agreement, you must include the shift differential in the rate of pay when you're determining what they would have otherwise earned during the time that they took off. Are you confused yet? To add to it, we've got some examples from the regulations, although we don't have an example for every situation. But here are the 3 that the regulations put out. One of them, and I think this is the questions we've had the most yet, right, Meg?
Yep.
Is what do I do if I'm paying employee commissions? Well, the regulations set out a 90-day look-back period. So you would have to go ahead and look to see what the employee earned over the prior 90 days, divide that by their total hours worked during the prior 90 days, and then you're going to come up with this calculation for normal hourly compensation. Similar it's not similar for piece rate workers. Our look back period is actually the most recent work week during which they worked the same. And then for employees who are paid a salary, we're going to divide that by 52 weeks in the year to determine the weekly salary, and then divide that by their normal scheduled hours of work. Now, note that that doesn't say 40 hours. So you want to be careful that what you're using as your divisor is really what the employee normally works. And I have clients with some salaried employees who work only 36 hours a week. So you're going to divide it by 36, not 40. These are complicated, and if you need to figure this out, I suggest you spend some quality time with the regulations. All right, when do you have to give them the paid sick leave? Well, you need to give that to the employees on the payday for the pay period in which they took the leave. So that means if I'm sick on Thursday, Friday, and my payday is the following Friday, which included that week I was out, that's when you're going to give me the PTO. There's no delay for the following pay period to do a catch-up payment. Okay, what happens when an employee quits or is fired? But I like to think about positive things this early in the morning. Believe it or not, 10 o'clock's early for me. You don't have to, again, as I said before, pay out unused PTO, but you have to have it in writing if you're going to choose that option. And if you don't, then you're going to need to pay it out. All right, here's the next fun part about this law.
So there's also a carryover requirement. So at the end of the year, any unused paid sick leave of 40 hours, you have to allow your employees to carry over at least 40 hours of that unused paid sick leave to the next year. So keep in mind, we've gotten a lot of questions. If an employee carries over that 40 hours of unused paid sick leave to the following year, accrual of that paid sick leave in the subsequent year would be in addition to that 40 hours accrued in the previous year and carried over. So this is important for front-loading policies. So when somebody carries over their 40 hours from the previous year, you front-load on top of that 40 hours.
And that's because there's no cap on the accrual or no cap on the amount of hours that you must give an employee, unlike Seattle allowed. That's different here. I also want to add that it's 40 hours or less. So if I only have 20 hours unused at the end of the year, I'm going to carry them over. So basically think of it this way. If I have 20 hours unused at the end of the year and I'm sick on January 1st, I'm going to have those 20 hours available to me to cover that sick day as of January 1, even if I'm starting to reaccrue for that next year if you use a calendar year method.
Correct.
Did I get that right,
You
Meg?
got that right. But what does it all mean, Basil? So if you can you combine sick and safe leave with vacation? So this is the idea of a PTO policy. Yes, but PTO policies have to meet the provisions of the Washington Paid Sick Leave Law. So accrual has to be at the same rate. Payment has to be at their normal hourly compensation. They have to have that carryover provision where they can carry over the 40 hours of unused accrued paid sick leave from the previous year. And employees have to be permitted to use the PTO for all the purposes that the Washington Paid Sick Leave Law covers. And there's quite a few record keeping and notification requirements that your PTO policy will also have to comply with. And this is another question that we've gotten quite a bit of. So if you have a PTO policy in place and it meets all of the provisions in the Washington Paid Sick Leave Law, and let's say the employee uses all of their PTO for vacation and not for one of the reasons under the Paid Sick Leave Law, but then all of a sudden they get sick or one of their family members gets sick and they want to use paid sick leave, but again, they've exhausted all of their PTO, do you have to give them more paid sick leave? And the answer is no. You've already given them their share of their paid sick leave hours, and if they choose to use those hours for reasons not related to paid sick leave, that's on them. And then there's shared leave. You can have a shared leave program, paid sick leave program, but you must have a written policy. It has to be readily available to your employees. You have to, of course, you should train your employees on this or let them know about it. And you have to do that before you implement the policy.
And paid sick leave donation programs can raise tax issues. And so that would be something that you would want your benefits attorney to vet as well if you're going to have a policy in place that allows for sick leave donation.
And hopefully some of the questions along these lines will be cleared up when the guidance and the FAQs are released. Swapping shifts. This is another important thing to keep in mind. When an employee is using paid sick leave law, they are under no obligation to find a replacement employee to work for them while they are using paid sick leave. Employers and employees can mutually agree that the employee can switch shifts in lieu of using their paid sick leave. So if I'm really sick today and Catherine can take my shift, I can go ahead and have her do that as long as the employer is okay with it and then work her shift later in the week.
But I'll never work your shift for you.
Oh, come on.
Okay, so back to my favorite topic is what do we do about our leave abusers? I do hope they're few and far between, but as employment attorneys, we tend to deal with the exceptions rather than the rule. So if you can demonstrate that an employee used paid sick leave for an unauthorized purpose, you don't have to pay it. But here's the problem with this rule. Notice that the onus is on the employer to prove that the employee used paid sick leave for an unauthorized purpose. So because of the risk of a wage claim or a failure to pay paid sick leave here, you're going to really want to have your ducks in a row, that you can prove that the employee said they were sick and then went to their cousin's wedding. Yes, that's happened. But if you don't have a Facebook posting of the employee's picture standing next to the bride, I might really question about whether you can meet that standard. Also notice that you're just withholding payment for the PTO that the employee claimed. You're not deducting time from the bank. You can't do that for what's been legitimately accrued, or you're going to run afoul of this law. Other responsibilities. You must notify employees, either in written or electronic form, that they are entitled to paid sick leave. Oh, that sounds like a handbook revision or a standalone policy again, doesn't it, Meg?
It sure does.
You've got to tell them the rate at which they'll accrue. So even if it's 1 hour for every 40 hours worked, it's just the minimum. You need to put that in your policy. You need to describe the authorized purposes for which paid sick leave can be used. That's going to include the sick and safe leave reasons that are in the law itself. If you're going to go ahead and allow there to be vacation or personal days as well, you would need to reflect that in your policy. Your stated policy also needs to include a provision explaining that retaliation for an employee exercising their rights under this law is prohibited. And this information has to be readily available to employees and must be provided no later than the first day of employment. The state is giving you a little bit of time to get your written policy in place, which would be March 1st. But keep in mind, that's really just a delay in writing it up because you need to start the accrual on January 1. So if I was prudent and didn't have 100 other things to do, I'd be getting my written policy in place before the end of the year.
So there are record-keeping requirements under this law, which include at least monthly, the employer must provide each employee with notification detailing the amount of paid sick leave the employee has accrued, any reduction since the last notification, so the last time you notified them about how much they had, if they've used any, and any unused paid sick leave available for use by the employee.
And so you could do that as a line on a paycheck, right?
Yeah, certainly. And in fact, that's one of the things that the state has recommended is to put it into your payroll statements.
What about if I just had somebody keep track of it in QuickBooks or Excel and I gave that to my employees when they got paid?
Yeah, that
probably works too.
That works too. I think, you just want to have one policy, keep it consistent, and it shouldn't be too hard to implement on a paycheck.
And be sure it's accurate.
That too. So for the record keeping, again, a lot of these things are already covered under wage and hour law in Washington, that you already have to keep a lot of these records. We've highlighted some of the new ones that you will have to also keep in mind under this law, which include paid sick leave accruals each month, and again, any unused paid sick leave available, and paid sick leave reductions. Again, the rest of those you should already be keeping track of. So hopefully you are.
So as I mentioned at the top of the call, we don't have final rules regarding enforcement yet. The rulemaking process is still ongoing. In fact, if you want to be involved in the rulemaking process, you can go to the Initiative 1433 engagement site through Labor and Industries. Remember, paid sick and safe leave was one of the things that came out of that initiative, so that's why it still shows up as 1433. And you can give comments to the proposed enforcement regulations or share what you think. Unfortunately, the time has passed to give any comments about everything else we've covered to this point. All right, I think we wouldn't be surprised to learn that employers may not interfere with any right protected by the sick and safe leave law. So that's the employee who calls in and says, I've got the flu, I can't come in today, and I know I've got some sick leave available. I'm going to take the day off. at that point, the supervisor can't say anything. Well, I really need you here, and if you don't come in today, I'm going to fire you. Or you're really causing problems for everybody else if you don't show up. And in fact, in that hypothetical, you can't even ask for a sick leave note, right, Meg? So that's what they mean here. The next one is using the employee's use of paid leave as a negative factor in any employment action. All right, let's break that down.
I would include in this one, switching somebody's shifts or cutting their shifts. We've seen that happen when employees are trying to exercise their rights under these laws. An employer will all of a sudden only give them, the bad, quote unquote, bad shifts, or will cut their hours significantly.
Right. So, and the excuse really isn't going to work. Well, I need somebody who's here reliably. If they have paid sick leave available and they're exercising it validly, then cutting shifts for that isn't going to work. Another example would be and folks should be used to this just because of disability discrimination issues, but counting somebody's attendance against them in performance reviews or considering raises is going to run afoul of this law too. So we have a new set of laws where we could have a similar type of claim than what we've seen before. Again, the third one, it's subsumed in what we've just talked about, which is if you're counting use of leave for an authorized purpose, that something's going to lead to discipline. Again, I still see every once in a while a no-fault attendance policy or an attendance policy that's trying to count days, and you really have to have an exception for valid days off that are covered under Washington's new law. And I think the last one's really obvious. We're not going to fire people or tell them we're going to fire people if they take a day off and they have coverage. All right, so what do we do if we've got employees all over Washington? This is the challenge. Right now we've got Seattle, SeaTac, Spokane, Tacoma in place. None of them are identical, and I'm going to walk you through that. Spokane, in fact, helped everybody out by including an automatic sunset provision for when the state law takes effect, Spokane's law goes away. So as of January 1st, 2018, if you've got employees in Spokane, you only need to worry about Washington's law. Tacoma has also changed a bunch of its law to match the new Washington law to try to bring about some consistency. But there's some examples there of a but, again, as well. So let's go through those. Okay, well, employer size for the state, we talked about that. It's everybody. Seattle had to have at least 4+. Tacoma was everybody in every employer as well. And remember, the SeaTac law applies only to certain defined hospitality and transportation employers, as well as hospitality and transportation employees. Type of employees, we said all here. We did have some exceptions that Meg went through already, the white collar exception being a big one for statewide. But otherwise, the assumption should be that you need to provide leave. And remember, all these other laws are in effect, but Washington starts on January 1st, 2018. Note I left off Spokane purposely because we've got that sunset provision and I didn't want to confuse things further. Is there any requirement for the amount of hours that the employee needs to work within Washington state to qualify for paid sick and safe leave? No. I can already hear some of you on the phone wanting to know about when you have employees traveling from inside and outside state. That is too long of a question to answer in this call because it has to do with jurisdictional issues. But the basic rule is if you're performing work in Washington, you must accrue paid sick leave for the hours that you work in Washington state. I put an X through 80 for Tacoma because it isn't going to matter anymore. That's one of the things that they've changed. Seattle has a higher accrual rate for certain size employers. So you're going to need to follow that, at least for your Seattle employees if you're a large size employer. Otherwise, everybody else now is 1 hour for every 40 hours worked. The waiting period under Washington State is only 90 days, which I said at the beginning is a shorter introductory period than it is for Seattle's law. So that means you're not going to, if you have an employee in Seattle, they get to use their leave at 90 days, not at 180. You've got to follow the more generous provision. Let's talk about cash out. So cash out means, do you have to ever give employees money for their unused PTO? So far, everybody says it's dependent on just what you decide in your policy. The only jurisdiction that's different is SeaTac. If anybody's got employees in SeaTac, remember, you have to pay out their unused PTO at the end of the year, and you have to pay it out at termination. Now, what's interesting about that is there's this carryover requirement under Washington law, but SeaTac says you have to pay it out. How that's going to play out, I'm not quite sure yet. And if you have those questions, that's probably something to talk about offline. And the next piece is whether bereavement leave is covered. Well, it's only covered in Tacoma, but Tacoma hasn't gotten rid of that when it did its amendments to its law. So if you've got employees in Tacoma, you have to allow PTO to be used for bereavement. You don't as a matter of state law or in these other jurisdictions. Again, this is a question for you to decide what you want to do as an employer. Talk about some more differences. The big difference here is what Meg already previewed, that Washington's law requires a carryover and also does not cap annual use. That's very different than Seattle and is different than what folks are used to. I think that's going to be the biggest change in policies for people who are already having to follow local law. If you hadn't had to do that yet, then it's not going to be a concept for you that's different. And again, it kind of doesn't matter for Tacoma and SeaTac because of what the state law says. There is an annual use cap in Seattle, and it does vary by employer size. I've heard that maybe you have an argument that where the cap is higher than what Washington State would allow you to accrue, maybe you can still cap it. That's not, again, something I'm not going to answer in this webinar because I think that we don't have clarity on it. It's a little bit of a tricky area. Verification, we talked about that already. It's 3 consecutive days or 3 days of absences of scheduled time off, as we already talked about, and no exception for suspected abuse. So that's in red here because that's the rule you're going to need to follow. As far as the rate of pay, my suspicion is that the normal hourly compensation is defined under Washington law is going to be the more generous calculation. So that's the one that you're going to have to provide and use when giving employees their paid PTO hours. All right, hope everybody's still with me. The next question is, well, can I get sued if I screw this up? Maybe that wasn't your question, but it was my question. Can my clients get sued if this gets messed up? Well, under our state rule right now, it's all an enforcement action by the state agency. Again, though, I always worry about laws where we're requiring that we give certain amount of money to our employees because we have a very generous definition of what is a wage under Washington law. It's compensation owed by reason of employment. So, you know, Meg, I worry if you didn't give me my paid PTO hours, I think I could bring a wage claim against you for that, and then that's going to be double the damages owing. So while there's no provision for a specific violation in this law, you might need to be concerned about a wage claim. Seattle's law, remember, added after it was passed, there is a specific private right of action in the law itself that the city of Seattle not only has the right to investigate, but an employee can sue for it. So that still got bigger teeth. And then we're back to the SeaTac and Tacoma analysis as I just gave for Washington. There's nothing specific in the law itself, but I always keep a wage claim in the back of my mind. We have inconsistencies regarding the notification of paid leave available. Again, just to make it a little tougher for everybody. I think the easiest thing for employees is if you can afford to have your paycheck provider put it on the pay stub, then you're not going to need to worry about it, and that'll come out each pay period, and that'll match with everything. But if you're not in Seattle, I mean, really, it is just a monthly requirement, and you could come up with something outside of a paycheck tracking that you might be able to use that would work.
So turning to the enforcement rules, these are still in the rulemaking process, in the very slow rulemaking process. So we've been tracking these a little bit, and we can kind of preview what it's looking like. But again, these are subject to change. It's looking like you're going to have about 180, or employees are going to have about 180 days to file a complaint with L&I for retaliation claims for using their paid sick leave under the Washington law. L&I will then conduct an investigation, issue findings, and issue penalties. So it's important to keep in mind that this law is going to have teeth. For retaliation, right now the rules that are being proposed provide that for a first violation, it'll cost you about $1,000 or an amount equal to 10% of the total amount attributable to the retaliatory action, whichever is greater. So the max would be $20,000. Repeat violations can be up to double the civil penalty for the first violation, again, maxing that at $40,000.
That's some teeth.
Yeah, I mean, that could hurt. And the next part is enforcement for claims that the employee was not provided their leave when they asked to take it. Again, the employee can file with the Department of Labor and Industries and allege that their employer failed to provide them with their paid sick leave, and the department will investigate the allegation. As Catherine stated, right now there isn't a private right of action, and the department, upon this complaint, will, if they determine there's a violation, will basically give the employee the choice of whether or not they want to be paid the leave or just get money. So whether or not they want to get that paid sick leave or whether they want to be paid for the time that they took off.
We know we went through that fast, and there's got to be some questions. So you can go ahead and send us questions through the GoToMeeting. You should have received instructions on that, and we're happy to try to answer them. Somebody did ask a question about whether you have to do an accrual for salaried employees, or is this law just for hourly employees? If I can go back to that slide, the only folks who are exempt under the Washington law are individuals who meet the overtime exemptions for bona fide executives, administrative, or outside sales. So remember, for those tests, it's not just a salary, it's also whether the employees meet the specific duties test of those exemptions. So you'll need to check with your counsel to make sure that the employees you're trying to exempt from the Washington law are properly classified, and you'll want to understand what classification you are using. But just paying somebody a salary doesn't make them bona fide executive, administrative, or professional or outside salesperson. And just being a salesperson doesn't mean you're an outside salesperson. So there's a deeper analysis here then really we can go on through this webinar, but it is something to check when you're determining who is and not covered. Somebody asked, and it's worth clarifying again, if the employer wants to front load, do you still need to allow the carryover? And the answer is yes, you do. So if you front load, say 80 hours January 1, and you want to argue that that includes any carryover that they had, that isn't going to work the way that the law reads. You have to allow the additional time. And there's no cap on use for the year under this Washington law. So that may be one reason to separate it as to a sick and safe leave policy only, as opposed to have it be a lump PTO, because you could cap PTO use for vacation because that's still determined by policy, but you can't cap sick and safe leave use under the new Washington law. We will be providing copies of the slides, as I said at the beginning, to everybody who attended, so don't worry about that. Somebody asked a question about tracking paid sick and safe leave in 15-minute increments for salary employees or exempt employees. Hi, Karen, I know it was you. The answer to that question is leave tracking is going to be a little bit different for salaried employees because you have to follow the safe harbor provisions to not destroy the salary basis portion of the exemption test. But usually how you track the PTO versus somebody getting time off, there's a way to write the policy that's consistent with that, and have done that. We've done that for Seattle too, but that's probably a little bit more complicated than I can answer here. Someone asked about state required postings. Yeah, there'll be state required postings as well. I think I actually didn't check this morning to see if the posters were up yet. That's going to satisfy the rule about a basic posting, but it's not going to satisfy a lot of the requirements for some of the options under this law. Like if you're going to pay unused PTO out at termination, that's not going to be something covered in the free posters that the state will provide. So you're still going to need a written policy as well. But to try to get yourself in compliance right away, of course, you're going to want to grab whatever folks have done. Somebody asked, I've got a few questions about folks using their PTO, but they still fail to follow a call-in procedure. So the requirement is, I mean, generally, yes, you can require your employees follow their call-in procedures and you can discipline them for failing to call in. What you can't do is not give them the PTO if the reason was covered. And of course, that gets a little bit tricky because you want to be sure that you're not inviting a retaliation claim. But the other question that goes there is, you know, generally recommend that you do discipline the employer for failing to call in. You're also going to need to examine whether the reason the employee wasn't able to call in, say within a 2-hour window, was a 2-hour window wasn't for a reason that because, you know, they became suddenly ill or something. Folks have asked if this law speaks to prohibiting fitness for duty slips. There's nothing in here about that at all. So your practice should be consistent with what you've always done, which is somebody's out for 3 days, you want a note from their doctor saying it's okay for them to come in. You would need to consider disability discrimination implications there, but generally that kind of question is going to be an exception to that. Folks asked, well, if I can't ask for verification for 3 days, does that mean I can't require people to fill out a request for PTO? No, that doesn't mean that at all. You can still have employees follow whatever your policies are for asking for time off. Keep in mind, though, for sick leave, you usually don't know ahead of time. But if you're requiring an employee to fill out that form when they come back to work because it's how you track it, that's perfectly fine. I got several folks who asked about, can they have one policy that matches both Seattle and Washington? Sure you can. You're just going to need to pick whatever's more generous under each law and be able to marry them together so it all applies.
So that's important when you're looking at, who's included as a family member, those types of things. You would have to include all of those people as a family member.
Somebody had a question about the carryover. So the carryover is 40 hours of unused PTO at the end of each year, and somebody was concerned that that meant like you could have a 20-year employee who's never sick who has like hundreds and hundreds of hours. And the answer is no, they're not going to have hundreds and hundreds of hours because they can only carry over 40 each year. So it's not 40 one year and then 80 the next year and 120 the next. It's 40 at the end of each year. Someone asked if you can require that they use their PTO if they're out sick. Yeah, of course you can. This should be in the law. Some folks asked again if there's a cap on the amount that can be used in a year. No, that's one of the things that's different about this Washington law. There's no cap on use and there can't be a cap on use. Again, that might be a reason to separate sick leave out from vacation if you have a more generous vacation policy. I see several folks asking if the poster is going to be an S, and the answer is probably not. A couple folks asked if we're paperless with our pay stubs, but employees can access those online, or there's an HRS system. So either you have like access to ADP or Paylocity, or the HRIS system that's going to show how much leave is available. Yeah, that's fine. You don't have to print something out. Someone asked a question for a larger size employer. They pointed out that Seattle's law has a 52 hours carryover for certain size employers and Washington's is only 50. I mean, the answer is yes, you've got to follow the more generous law in that case, which would be Seattle's. Someone asked a question about part-time workers. It is measured by the time you work. So if you only work 5 hours a week, it's going to take you several more weeks to earn your first hour of paid sick leave. We've had a couple more questions about who's exempt. I want to just circle back again. It really is an issue of determining whether that employee meets the exempt requirements of the administrative, executive, outside sales, or professionals. Remember, executives are like your CEO. A professional is a learned professional. That's like Meg and I, we're attorneys, and we have professional degrees. I'm not really sure how learned we are. But
I feel pretty learned.
I feel pretty learned. We follow under that. It's not just somebody who is a software engineer. So there's no exception for someone who fits the computer workers exemption. They're exempt from overtime, but they're not exempt from paid leave under this law. That's an example of a difference. There was another question about whether you can waive the Washington state rules by a collective bargaining agreement. What is that, Meg?
So unlike the Seattle ordinance, you can't waive these under a collective bargaining agreement. And in fact, all of the rules that we went over, you need to have a policy in place. Those policies should be in your collective bargaining agreement. And if you see the regulations, you'll see that. So collective bargaining agreements must include these rules and put your employees on notice. Somebody asked, because there's still some rulemaking, is implementation going to be delayed? No, it's not going to be delayed. It's January 1, 2018. You need to start accruing the paid leave for your employees. We may see some delay in the enforcement piece, but that's going to happen when we see when those regulations get done. They are due to be done before the end of the year, where they're just not done yet. And we didn't want to delay in doing this webinar anymore because folks really need to start thinking now about how they're going to compliance. There's a lot of questions on here about requiring employees to give reasonable notice of their absences. Again, the answer is, of course you can require that, but you have to remember that there might be sick or safe leave covered reasons where the employee can't comply with that, and you need to have flexibility in your policy to allow for that. You need to look at whether or not it's foreseeable or unforeseeable. That's one of the deciding factors.
There's a lot of questions here about dividing up sick leave and PTO. I mean, the answer is, if you have a PTO policy that allows for more time than what Washington state sick and safe leave policy is, yeah, you do need to be careful about articulating what the carryover is and such. I mean, I've done combined PTO policies where it's quite generous, but you still have the carryover be the 40 hours, so that therefore you can say that it has met the Washington rules. Somebody wants to know if they can deny time off if it's for vacation. Of course you can. That's different than a covered sick or safe leave reason. Looks like we're out. I'll take a look here and see if there's any questions. Some folks asked about just transferring over existing balances into the bucket. The answer is you still have to do the accrual. The remainder of these questions here, I think, are actually answered in the slide or something that we talked about. But again, if I see anything here that aren't super specific to your policies or generally, we'll put that in our answers to the emails. And thanks everybody for listening, and we hope you have a great weekend. We'll be going over more of these issues in our annual seminar, which is going to take place in December. So that's another place where you might be able to get your questions answered about this. We also cover any annual updates on Washington and local law as well. And we feed you, and it's going to be free this year. So if you have any questions or are interested in that, we've got an email here for somebody that you can contact, and we hope to have a chance to meet you in person in December. Thanks very much.
Thank you.